Good morning and welcome to the ParkBridge Wealth Management Spring Webinar Series. This program is entitled Unraveling the Challenges in Estate Planning, Navigating Copyright Law and Preserving Creator Content. As always, my name is Jonathan Shenkman. I'm the President and Chief Investment Officer of ParkBridge Wealth Management. In that role, I serve in a fiduciary capacity to help my clients achieve their financial objectives. The goal of my program is to bring professionals together to help them better serve their content. It's better to serve their clients. This is done by educating attendees on the latest topics in wealth planning and by encouraging collaboration between a client's attorney, CPA, and financial advisor where appropriate. My practice focuses on working with high net worth families, businesses, and not-for-profits. I manage individual investment portfolios, trust accounts, corporate retirement plans, and endowments to help my clients achieve their financial goals. In addition to the 20 or so events I run every year, I also do a fair amount of writing on the topics of investing and financial planning, and you can read my work in a variety of periodicals, including Barron's, CNBC, Forbes, Kiplinger, The Wall Street Journal, and Trust and Estates Magazine, to name just a few. You could also see all my work on my website at parkbridgewealth.com/articles, or by following me on social media at Jonathan on Money. Additionally, you can check out my weekly podcast, which is also called Jonathan on Money, and you can listen to that on Apple, Spotify, or wherever you get your podcasts. Before I introduce our esteemed speakers today, please pay close attention if you are an attorney or a CPA in Connecticut, New Jersey, or New York and are taking this program for credit. I'll be giving a code during this program that you will need to write down. There will only be one code. It will be given at some point in the middle of the session, so have a pen and paper ready. After the program, you'll receive an evaluation form where you'll need to insert the code in order to receive credit. Please stick around until the end of the program for further instructions on receiving credit. Today, we're privileged to hear from Marc Misthal and Yeung from Offit Kurman, based in New York City. Marc is a principal attorney in the firm's intellectual property practice group. With a wide range of clients worldwide, Marc provides counsel to businesses spanning diverse industries, including fashion, apparel, computer technology, hospitality, entertainment, luxury goods, consumer goods, and many others. As part of his practice, Marc has represented clients in federal courts around the country, defending and prosecuting claims of trademark, trade dress, and copyright infringement, and when necessary, obtaining injunctive relief. Marc's experience extends to negotiating license agreements, working with law enforcement to combat counterfeiting, filing, and prosecuting trademark applications before the U.S. Patent and Trademark Office, and filing applications to register copyrights with the U.S. Copyright Office. Michelle concentrates her practice on estate and tax planning, Medicaid and special needs planning, and trust and estates administration in New York. Michelle works closely with multi-generational families, families with special needs, minor or adult children, same-sex couples, property and business owners, and individuals with all levels of wealth. Michelle prepares wills and various types of trusts, such as generation skipping tax trust, credit shelter trust, Medicaid asset protection trust, supplemental needs trust, life insurance trust, and many more. In addition, Michelle works closely with families and individuals to protect their assets and to minimize their federal and New York estate tax liabilities. Today, Marc and Michelle will be speaking about unraveling the challenges in estate planning, navigating copyright law, and preserving creator intent. And with that introduction, I will now turn the program over to Marc and Michelle.
Thank you, Jonathan, for that very kind introduction. Good morning, everybody. We're glad that you could join us. And Jonathan, thank you for inviting for us to present. We appreciate the opportunity. Before I get started with the substance of the presentation, just one thing to mention. Michelle and I are both with Offit Kurman. Offit Kurman is a full-service law firm. As Jonathan mentioned, I am in the intellectual property group, and Michelle is in the trust and estate group. With that, I think we're going to dive right in and get started. So, Michelle, if you can advance us a couple slides. For anybody who didn't catch the bio, there it is. Michelle, let's go right to the next one.
That's my bio.
And this is just a short agenda of the topics that we're going to be covering today. The program today really focuses on copyright because there are some particular statutory provisions that affect copyright and how it can be left to one's successors and heirs. So with that, let's get started. So Michelle, if you can go right to the next slide. Thank you. just to start off, we're going to talk about copyright and what it protects. We've got the definition right there on the screen from the statute. Copyright protects original and creative works of authorship fixed in a tangible medium of expression. There's a lot in there, so let's unpack that. You can see we've defined some terms up on the screen. Original and creative kind of go together. Is not a very high threshold for what is original. That generally means something that's not copied. Creativity is also pretty low threshold. There's a Supreme Court case that says the way that you organize a phone book might be sufficiently creative as long as it's not the standard ABC listing. And fixed in a tangible medium means something more than in your head. It's got to be written down or saved. It can't just be something that you're thinking of. So we're really talking about things that have been produced that are creative. Michelle, before we get to the next slide, there's one other thing that I think is helpful to discuss. We talked about what copyright protects, but we should also talk about what rights it gives to the owner. So the owner of the copyright has the right to reproduce the work, the right to create what's called derivatives, which we'll talk about in a minute, to sell copies, hence copyright, to perform the work publicly, to display the work. This is all set out in Section 106 of the Copyright Act. Michelle, let's go to the next slide. We have on the screen here two examples of works that are protected by copyright: a book, as mentioned, and a movie, which is considered a derivative work because in this case it's based on the book. There are other types of works that are protected by copyright. This can include musical works, plays, choreographic works, sound recordings, pictorial, graphic, and sculptural works, which includes photographs. It also includes architectural works, which there's an amendment on the table that may even extend that architectural work protection to certain features of golf courses. We'll have to see if that passes. So let's, Michelle, go to the next slide, please. Thank you. We're going to talk today a lot about the termination right that authors have. And in order to understand that right and why it exists and how it operates, we need to go back a little bit and understand why it was put into place and how it came to be. So that takes us back to the prior Copyright Act, which was the 1909 Act. And the 1909 Act was very formalistic. In order to get protection, you had to register the work, you had to renew the work at a certain point in time, which we'll talk about. You had to use copyright notices. It was very easy to lose protection if you didn't do certain things. Renewal was needed because copyright, as it says on the screen, had two terms: an initial 28-year term, and if you renewed, a second 28-year term. And as mentioned, if you didn't file those renewal documents, you didn't get the renewal term. And they were pretty strict about that. So the question becomes, why were there two terms? Why was this renewal provision put into place? And the answer is Congress wanted a second term because they were concerned about authors being taken advantage of. Author is kind of a shorthand for creator in the copyright parlance. But Congress didn't want authors being taken advantage of. So the second term, at least in part, was intended to allow creators to renegotiate deals if their work had somehow become very successful, as some, you create a work, you don't know how successful it's going to be. This was an opportunity for them to renegotiate, for their families to renegotiate, and get a bigger slice of the pie, so to speak. So let's talk about an example of how that worked. And Michelle, if you wouldn't mind the next slide, thank you. Fans of the movie Rear Window may have heard this story before, but it's an interesting one, and it went all the way up to the Supreme Court. And the story goes like this. Cornell Woolrich wrote a short story called It Had to Be Murder. He published it in 1942. In 1945, he sold the movie rights. In that contract, he agreed to renew the copyright after the initial 28 term. That's a very important point. In 1953, Jimmy Stewart and Alfred Hitchcock bought the rights. They eventually made the movie Rear Window, which I highly recommend if you haven't seen it, but that's a separate topic. Woolrich died in 1968 before the first term of his copyright expired. So what happened then was control of the rights went to the executor of his estate, Chase Manhattan. They then sold the movie rights to a literary agent named Sheldon Aben. So he owned the rights, particularly in that renewal term. In 1971 and 1974, ABC aired Rear Window on TV pursuant to a license that they got from the movie company. Michelle, can we go to the next slide, please? Aben sued for infringement because he was not willing to honor that agreement that Woolrich made and renew the copyright and assign it to Jimmy Stewart. And the case went up to the Supreme Court for resolution. And what the court said ultimately was, if the author dies before the renewal term, an agreement to renew and assign that renewal term does not have to be honored because it's merely an expectancy. If the author survives to the renewal term, then the agreement requires that he must renew because it's an actuality, not an expectancy. Now, this shows how things worked under the 1909 Act, even though it was decided in 1990. The case is of relatively limited value because the act has changed. And let's go to that, Michelle, if we can move ahead. The new Copyright Act took effect in 1978. It had some significant provisions. It kind of kept the renewal scheme. It increased the length of the renewal term. But there was one big change. For works created after the act took effect, there was no more renewal. Copyright would last life of the author plus 50 years, and that was eventually changed later on as well, the duration, but there was no renewal. So that was significant. Before we get to how that impacted the author's right to renegotiate, Michelle, let's go to the next slide and talk about who owns copyright in a work. Generally, it's the author. The big exception is in what's called a work made for hire. This term gets bandied about a lot. What it means in the copyright context is a work prepared by an employee within the scope of his or her employment. So during your job, if you write something, that's owned by your employer. That's a work for hire. We're going to come back to that. There are some additional exceptions that constitute works for hire. We're going to come back to this, but this is important when we get to the termination provisions, which is the next thing we're going to talk about. So Michelle, next slide. The termination provisions, unfortunately, are not easy. There are two provisions in the Act dealing with this. They're basically the same. The reason there are two provisions is because one, Section 203 deals with grants that were made before the 1976 Act took effect, and the other one, I'm sorry, I've got it backwards. 203 deals with grants that took effect after the 76 Act went into effect, and 304 deals with grants that were made before the Act took effect. It's important to note that the termination right does not apply in all instances. Specifically, it does not apply to works made for hire, or to grants made by will, or to grants made by somebody other than the author. We're going to talk about these things more, but this is why the question of ownership becomes important, because termination does not apply in every case, and it depends in part on who the owner is. Let's go to the next slide. There are some other exceptions. It doesn't apply to derivative work. So if the author said that somebody could make a movie, it doesn't terminate the right to exploit the movie. It may terminate the right to make future movies, but that movie can still be displayed and shown. The other thing that's important, and in today's world, this is a big deal, this only applies to US rights. So an author may have rights elsewhere in the world. Termination only applies to the US rights. And again, we come back to the question of why do we have this at all? Well, this is how Congress decided to address the lack of a renewal. The renewal term allowed for renegotiation. This termination scheme is the substitute for that. And Michelle, let's go to the next slide. So termination goes to the author. If they're deceased, it goes to their survivors. And then you've got the question, if the author is deceased, who can exercise the right? It's any combination of survivors who own more than 1/2 of the interest. Michelle, let's go to the next slide, which I think is yours.
Yeah. So I want to start off by discussing what is testamentary freedom. Well, everybody has testamentary freedom, and this is what you have to distribute or dispose of your property at the time of your death. You have specific rights of who you want to receive the property. You can say who will receive it, your spouse, your children, your best friend. You have the ability to say or appoint when they will receive that property or asset, when they reach a certain age, like 25, 35, when they graduate from college, or when they get married. You can set the terms for when anyone receives your property. You can even set the terms of how they enjoy that property, such as, they can only use your home for a residential purpose, or they can only use the money to support their education and health. No lavish vacations for them. So everyone has that freedom with regards to their property. And if you don't exercise this testamentary freedom, your domiciliary estate, the state that you reside in, has a statutory plan in place for you. In New York, this plan is in the New York Estates Power and Trust Law, Section 4-1.4, and it lays out the order of individuals who would receive your assets. They obviously favor family. Your spouse and children will come first. Then next would be parents and siblings, grandchildren, nieces and nephews. But that's the plan that every state will have for their residents. The great thing about testamentary freedom is you have the option to opt out of your statutory plan in your state. So if you don't like the plan in your state, like if you say, me and my spouse, we don't want to distribute our assets to each other, we prefer to give our assets to charities, you can do that. How do you do that? You create a will, you create a trust. You can lay out a plan that's different from your state statute. Now contrast that to statutory heirs. So what Marc has been talking about is these termination rights, right? It allows the family and the author second bite of the apple. But the problem here is now it also created a bunch of statutory errors. What I mean by this is that the termination rights that are granted to the individuals, the spouse, the children and grandchildren of the author are inalienable and unwaivable. And in the purpose of this is to protect, obviously, the family if the author has granted their rights to a large music company or publishing house. You want to allow the author and the family members to terminate that grant in the future. However, what happens when the author granted his property or transfer his copyrighted property to his best friend or to a charity, somebody who is not part of the people who would have this termination rights? Now we've created this unintended consequence where we've given these people the ability to terminate the author's original intent, such as giving their copyrighted work to charity. And a case I want to use to illustrate this point is the Ray Charles Foundation versus Robinson. So Ray Charles is a famous singer, songwriter, pianist. He was blind, but he learned to play the piano. Ray founded the Ray Charles Foundation to provide support for those with hearing disorder. And he named the foundation as the sole heir of all of his royalties during his life and thereafter. And Ray, I didn't know this, but Ray had 12 children from 10 different women. And at the time of his passing, he was not married. He had a plan. He gave all of his children, all 12 of them, each $500,000 in exchange that they would waive their right to his estate. Ray died before the termination window opened, meaning he didn't exercise his termination rights. So what does that mean? They passed on to his children. And after his death, 7 of the 12 children served termination notices on the foundation. And keep in mind, termination rights are unwaivable. Ray Charles was not able, or he couldn't have contracted with his children or made promises to his children to ask them to not exercise this right. And I also want to point out, as you can see, 7 of the 12 children served termination notices. That means that the children had to bind together and have a majority in order to terminate the grant of the royalties to the copyrighted works to the foundation. Interesting enough, this case was not started by the children. Actually, the foundation filed suit to challenge the terminations because the foundation's sole source of income was from the royalties. The court did grant them standing to bring the suit, but nothing, no further suit was followed. We don't know what is the outcome of this case. It would have been very interesting. All we can speculate is that there must have been some agreement made upon the foundation and the children so that the foundation can remain, because it is still in existence today. Go ahead, Marc.
Boy, so this kind of brings up the question of, well, how does all of this work? And like we said before, it's complicated. So what we've got on the screen is the language from the statute. And for purposes of our discussion here, we're focusing on section 203. 203 and 304 both act pretty much the same. But everything we're going to talk about today is under 203. But you can terminate a grant at any time during a period of 5 years, beginning at the end of 35 years from the date of execution of the grant. To me, that's a mouthful. So I think the example down below is helpful. If the grant from the author to whoever, let's say the Ray Charles Foundation, was made on January 1, 85, the date of the grant plus 35 years is January 1, 2020. So you have a termination window of between January 1, 2020 and January 1, 2025. The termination date can be any date between those two in that range. Let's go, Michelle, to the next slide. There are some other considerations that make this more complicated. We're going to stick with keeping things simple this morning. So let's move on. Because now that we've got we know when it can be terminated, the question becomes, well, how do you do this? And the way this is done is a termination notice has to be served on whoever received the grant and potentially their successors in interest. And there's a time frame in which that has to be done. And that's up to 10 years before the selected termination date and no later than 2 years before the selected termination date. So again, we've got an example to walk through this, and this carries on from the prior example. But if we say we're going to choose a termination date of January 1, 2024, the window for serving that termination notice is between January 1, 2014 and January 1, 2022. And you can see the calculations there, but you've got to make sure that you get those dates right. Let's, Michelle, move on to the next screen. Again, we're keeping things simple. There are other considerations if we're talking about works that are joint works and some other works. We're going to keep things on the easier side this morning. It's still a little early. Michelle, let's move on. So here we have an example of what a termination notice looks like. And, frankly, it's not really anything special. It's basically a letter. This is actually from a case that Michelle is going to speak about in a little bit. But you can see that it's a letter that says certain things. And if we go, Michelle, please, to the next slide. There's a whole list of information that needs to be included in the termination notice. It's all set out in Copyright Office regulations, and it's listed here. Let's go, Michelle, to the next slide. Some additional requirements. The key thing here is twofold. First, the termination notice has to be recorded in the Copyright Office before the effective date. If you don't do that, it's going to impact the effectiveness of the termination. And if you don't comply, the termination notice can be invalidated. So if you serve a notice and it doesn't list one of the 7 things that we've had up on the screen here, one thing is left out, that can invalidate the notice. It's really important to make sure that the notice says everything that it's supposed to say and that it's recorded with the Copyright Office. Because if not, many of these cases find their way to litigation. One of the things that's going to wind up being litigated is whether the notice is effective or not, and you don't want to have that issue. So it's really important to make sure that these things are all included in the notice. And I think, Michelle, I'm going to turn it back over to you.
I'm just going to interject real quick here with the code. It seemed like a good entry point. For those who are going to take this or taking this course for credit, accountants, attorneys in Connecticut, New Jersey, New York, please get ready for the code, which is E22. Again, E as in Eric, the number 2, and again, the number 2. One final time, E22. Please stick around to the conclusion of the program for final instructions on how to receive your certificate. Back to you, Michelle.
Michelle, before I turn it over to you, I'm going to just add one thing. Michelle's hinted at this, and she's going to talk more about it. These termination notices can give rise to all sorts of disputes, including interfamily disputes. The Steinbeck family had a long litigation over stuff like this. You may have heard that comic book artists have had similar attempts at trying to terminate things. There's a lot of litigation over this, even if things are done right. And Michelle, I know you're going to talk about some of that.
Thank you, Mark. Okay, so we talked about termination notices and rights. So, but what are the exceptions? One of the exception is works made for hire. And that means any work that was created by an employee within the course of his or her employment. This is usually, the more usual case. And another type of work made for hire is any work that falls into one of these 9 categories. And as you can see, going down the list, there are more works that are made in large groups, or works that are such as translation or text, or creating instructional text or tests. They're really not works that are creative in instance. It's where someone would hire a person to create this manual for the product that the employer has. Now, I want to point out that if you look at this list, you don't notice musical or sound recordings. And there's actually a reason why it's not there. So in 1999, Congress passed legislation intending to add sound and music recording to the list of collective works. They came down under fire for doing this, because this change, adding music or sound recordings to this specific list, basically took all the rights from a music artist and permanently gave them to the music industry or the recording companies. Because now anything that an artist would record while they're with a music company would not belong to them, and they would have no termination rights. So they shortly took that off. It was removed from the list. That's why music and sound recordings are not part of this particular list of items that are considered works made for hire. And I wanted to use a case to highlight what is work made for hire. And then a case on point is Game of Life. I'm sure everybody have heard of this game or played this game at some point in their life. Ruben Claimer was a toy developer, and he came up with the idea to update a board game. It was called Checker Game of Life. He was a toy developer. He didn't really have the background to design the prototype for the game to market it to the toy companies. So he hired a well-known game designer, Bill Markham, to help him develop the prototype for the Game of Life. And Claimer with Markham and also 2 additional Claimer's employees from his company worked and built the prototype for Game of Life. And if you know this game, you know that it has a spinner. It's not a flat game. It has pieces that kind of go up and down, the little cars with the people. It's a well-designed game, and that was because of this team. When the game was done and they had a good prototype, Claimer enlisted TV personality Marc Letter to pitch the game to Misthal, and they were able to enter into a license in 1959 to produce the game. Markham assigned his rights to the game and in exchange for 30% of the royalties. And Markham was also reimbursed for the cost that he paid into creating the prototype. Now, Markham felt at the end, because we know this game is still in existence, it's still in production, and he felt that he got the short end of the stick. He didn't feel he was given enough royalties for his work. So in 2019, his heirs sued Claimer's heirs and Leaf Letter and Hasbro to terminate the 1959 assignment. Well, the court held that his work was considered work made for hire. And I want to go back in why the court held this. Because if we look at the year that the assignment was made, it was made in 1959. And this was before the 1976 Act that Marc pointed out. And in 1959, work for hire had a different definition, had a different test. The court applied the instance and expense test. So instance means whether or not there was direct supervision of the creator's work. Did the creator have full control over the creative aspect of the work? And in this instance, Markham worked with a team, and it wasn't his idea. He kind of was brought on to kind of make the idea better, work on a prototype. He also worked with claimers to other employees. So, there definitely was some supervision by claimer. And also the expense test. How was Markham paid? Well, Markham paid for the prototype, but he was reimbursed. The reimbursement was regardless of whether the game became a success or not. So because of these two instances, the court stated that this was work made for hire, and Markham was not permitted to terminate his grant for this copyrighted work. Now, contrast that with a different case, something a little bit more recent, Horror Inc. versus Miller. In this case, Victor Miller wrote the screenplay for the original Friday the 13th film. At the time, Miller was a member of the Writers Guild of America. And I wanted to point out that in his contract, expressly did not provide that screenplays would be work made for hire. So he did assign, grant his rights to this screenplay in 1979. So again, important to pay attention to the year. 1979 was post 1976. So at that time, the new act was enforced, and Miller served his termination rights notice in 2016. So the court in this instance did not use the same test that they applied in the Game of Life case. Instead, they looked at the contract. They really looked at whether or not this, what was the agreement between Miller and the employer, and pointing out that the screenplays were not considered work made for hire. Miller reserved as he still had the termination right, and he was able to terminate his grant, and he was able to regain the copyrighted work of the screenplay for this film.
Michelle, before we go on, can you talk about a little bit more about the factors that the court looked at in terms of how they determined if it was a work made for hire?
So I think it focused on the contract that was between Miller and the Writers Guild, looking at the time what was his course of employment, what was he hired for, and that was because the contract specifically said screenplays were not made for work made for hire. Then that particular work fell outside of his scope of employment.
If I remember right, I think you're right, but I think they also looked at some other things which were not covered by the contract. The contract didn't talk about how payment was going to be made, and taxes weren't taken out. There was no withholding. There were no benefits. Miller wrote kind of on his own. There were some allegations, if I remember, that other people contributed some ideas, but they were never able to detail, except for a change at the ending. They weren't really able to detail who contributed what. So there were a lot of factors. There's a Supreme Court test that lays out the current set of factors for determining if something's a work for hire or not. The contract was certainly something that was considered, but definitely there were some other things that I think the court looked at, and it's important to keep those in mind. It's not, determining if something is a work for hire is not easy. I'll leave it at that.
Thank you, Mark, for including that. Yes, it definitely is not easy to do the termination. All right, let's move on. Okay, so now that we know that work made for hire does not include termination rights, how can we use that to help our clients who are looking to plan or grant their copyrighted works to people who are not their spouse, children, and grandchildren? All right. Well, if we know work made for hire does not have termination rights to protect our future works, the author can establish their own loan-out company and then employ themselves. So a loan-out company allows the author to create this company. They're the owner of the company, but they employ themselves to be the employee of the company. So all the work that the author makes while they're an employee of the loan-out company is considered work made for hire. Well, authors do create these loan-out companies not just for estate planning purposes. If they do it for that purpose, there's actually a lot of favorable tax benefits, such as, and also limit liability protection. They also enjoy employee benefits, health insurance benefits, and retirement account benefits, things that you wouldn't necessarily have if you were a freelancer or independent contractor. Having that loan-out company provides those employee benefits for the author. While they're working on their craft and making the works that they do. The thing is to point out is that if you already have, if the author already created copyrighted work, transferring that work to a loan-out company does not terminate or does not get rid of the termination rights. So if the author already has a successful book that they have wrote and they are planning to give that copyrighted work to their best friend, they cannot create a loan-out company and grant the book to the loan-out company in hopes that, oh, it's in a loan-out company, it's no, there are no termination rights. That's incorrect. The work had to be created while the author was an employee of the loan-out company, not created before and then subsequently granted to the loan-out company. I also wanted to highlight the different terms of the protection, copyright protection between work made for hire and works that are not made for hire. So work that is made for hire has the copyright protection of 95 years from the date of publication or 120 years from date of creation, whichever expires first. And then copyrighted works that are not part of work made for hire is the life of the author plus 70 years. So depending on the age of the author, you may actually get a longer protection through works that were made for hire, because if the author created the work when they're much into their senior years, even if they haven't published it, they'll get 120 years from the date of creation. So something to be aware of. All right. Again, just highlighting how to use a loan-out company to help plan. You must establish the company before you create the copyrighted work. And then after the copyrighted work is created, you can assign and transfer those works to the intended beneficiaries or the charitable foundations that the author has created. Obviously this is really a plan that will work for authors who are more seasoned and established. Authors who are young or just started in their craft may not find this beneficial because they may want to preserve their termination rights for themselves. And a case to highlight that is Columbia Pictures versus Gallo. So George Gallo and Bob Israel wrote the screenplay Bulletproof Hearts. At the time, Gallo was an employee of his own loan-out company called Sweet Revenge Productions. Israel did not have a loan-out company. Together, they wrote the screenplay that later became the very popular movie Bad Boys in 1995. In 2022, Gallo and Israel served termination notices to get the copyrighted work back. I want to point out here, Gallo tried to serve termination notice. At the time, he was an employee of his loan-out company. It was not the loan-out company who served the termination right, because if you remember, works made for hire don't have termination rights privileges. So this is an ongoing case. There is no outcome yet. You can see the date of this case was brought June 23rd, 2023, and Marc has mentioned there's a lot of litigation and these things do go on for a while. But there are remaining questions, right? Is Gallo's termination notice valid? At the time, he was an employee of his own loan-out company. Is it valid? Well, what about Israel? Israel created or wrote the screenplay with Gallo. They are 50-50 owners of this screenplay. And as we recall in the earlier presentation, you need majority owner in order to serve the termination notices. So if Gallo's termination notice is invalid, how does that affect Israel? We don't know this yet. Again, this is still an ongoing case, but it would be it would really be unfortunate for Israel if he wasn't able to terminate because of Gallo's loan out company at the time when he wrote the screenplay.
Michelle, before we go on, how do you think this one's going to turn out?
Well, if we go by statute and just go by the rule, I'm gonna I feel bad for Israel. That's all, right? If Gallo did not have a loan out company when he wrote the screenplay, they are 50% owner of this screenplay. They would have been able to serve this notice and terminate together, but because Gallo's termination rights is in question, it's going to be a tough case, and I'm actually interested to see how this turns out, because the precedent it's going to set out is going to affect people who could be considered using loan out companies for estate planning purposes in the future, because it is one of the methods that we can use to hedge against the statutory heirs from exercising these termination rights.
Reading between the lines, I'm taking it to you to mean that you think Colombia right now has a good case, obviously subject to whatever comes out in discovery and whatever motions are filed, et cetera. But as things stand now,
well, yeah, I think so. It doesn't look good for them. Let's just put it at that.
fair enough.
Okay, so and other than loan out company, what are another option for authors to protect their grants to their intended beneficiaries? And another method is to create a will. And again, if you recall, termination rights are not applied to grants made through a will. And it pains me to say this as an estate planner, because I always advise my clients to do planning during lifetime. Do a revocable trust. Make sure your assets are in your revocable trust so that you could avoid probate. The courts in New York, especially New York City, are notorious for taking months, even years to probate a will. And so to save on cost, time, on headache, my advice to clients is to always have a trust. Assign your rights to your companies, your businesses, transfer all your assets, regardless of whatever type they are, to your trust. Avoid probate. But in the realm of copyrighted work, I have to take my word back and take a step back and say, in this instance, maybe the will is the better option, because grants made through a will is not subject to termination rights. So what should an author do? Or what should you advise your client? Know your heirs. If the author, your client, does not want to leave his or her copyrighted works to spouse, children, or grandchildren, then doing a revocable trust is not the best option, because if the termination window hasn't opened during the author's lifetime, those rights are inherited to the children and the spouse and the grandchildren. And as you recall, they're inalienable, unwaivable rights. The author cannot contract with his family to say, I will give you X dollar amount if you never exercise your termination rights. That is not permitted. He can still do it. This family will just get an extra bonus payment up front and still be able to terminate the author's grant in the future. So an option would be create a plan, a good plan, have a revocable trust, and do a pour over will. Purpose of the pour over will is to provide privacy, because all wills are a public document if they are probated in the court system. I'm sure most authors would prefer privacy. Have a pour over will that says all of my copyrighted works will be transferred to my revocable trust in the name of Michelle Yeung Revocable Trust. And going through probate, we have eliminated determination rights for this for the people that the author did not want to receive these copyrighted work. So I wanted to use a case to highlight that. And Marc has already shown you the termination notice that was served in this particular case, and it's Livingston versus J. Livingston Music, Inc. So Jay Livingston was music. He wrote many famous songs. He, including one of them is called "Whatever Will Be Will Be," and he had a very elaborate estate plan. He worked on it for over 15 years, and he had 13 trust amendments. And as an estate planner, that already sounds like a headache, but I'm sure he had great lawyers to advise him and help him create this plan. He wanted to provide for his only daughter and only granddaughter. Livingston only did not have elder children or grandchildren. It was just one daughter and one granddaughter. And the trust held all of the copyrighted works, all of his musical compositions. Livingston died in 2001, and in 2015, his daughter, Trevina, started to serve termination notices on over 50 of his music compositions. As a result, unfortunately for the granddaughter, Tammy, she starts to receive less and less royalties, and at the end, maybe even to none at all. Unfortunately for Tammy, she was unable to stop her mom because her mom was the one who had the termination rights. Her mom was the only one who could serve at the time, and her mom had 100% ownership of those termination rights. So even though Tammy was a grandchild of Jay, she couldn't do anything to stop mom. And slowly, mom was able to regain more and more grants of the work back to herself, and Tammy was left with very little. So, the lesson here was, had Jay done a will along with all the trust that he's done, then his plan wouldn't have been ruined by his daughter, because as my suggestion, creating a revocable trust, which Jay could have done with all of his amendments, set out a very elaborate plan for his daughter and granddaughter, but not do the grant, not have the copyrighted work actually funded into the trust or granted to the trust until his passing and through his will. It has to be through his will. Then by going through probate, the termination rights would not pass on to his daughter and would not have allowed her to ruin his plan. So as a recap, just beware what doesn't work. If your client, the author, wants to plan in giving his copyrighted works or her copyrighted works to individuals that are not his usual, family members, spouses, children, grandchildren, then really look to see what his plan is. And really at that point, consider whether or not a will would be a better option, or using a loan-out company and making the new works that the author will create in the future be considered works made for hire. So that there would be these options for him to plan to ensure the property goes to the copyrighted work goes to the author's intended. Keeping in mind that the termination rights are not waivable or unwaivable, inalienable. You cannot contract with the beneficiaries so that they agree not to exercise those rights in the future, and also to make sure that the author knows that he has these options, right? And seek out estate planners who are aware of these particular nuances in the copyrighted realm. And that's all for my presentation today. Marc, do you have any closing words?
I think what I would say is this is definitely an area that is not easy. There's a lot of pitfalls in terms of what's required by the Copyright Act and in terms of what is required in terms of estate planning. And it's definitely someplace where if you've got a client who has copyright rights, it's definitely a good idea to, whether it's us or somebody else, to speak with somebody who's familiar with this and can provide counsel so that no mistakes are made. Because the likelihood is there's going to be some litigation. we've talked about 3 or 4 cases here. Believe me, there's a lot more. There was one recently about Top Gun 2, because the original movie was based on an article, and the author of that article, his heirs, were suing to try and terminate the grant to try and get some money out of Top Gun 2. That decision just came down and they failed. But there's a lot of things that happen, and there's a good chance that litigation is going to ensue, especially if there's some amount of money at stake. So I think I would close with that, and I would close also with saying, you have our contact information up here on the screen. If you've downloaded the slides, you have it. Please feel free to reach out to either of us with any questions. We're happy to take them. We're happy to do what we can to offer guidance, etc. And I just want to thank Jonathan again for having us on. It's certainly much appreciated.
Great.
Yeah,
Thank you
thank you,
so much,
Jonathan.
Marc and Michelle. And if anyone has any specific questions, new business opportunities, or any other issues they'd like to discuss, please feel free to reach out directly to Marc, Michelle, or myself where appropriate. And I'll be sure to also include their contact information in the follow-up email to this program. As I mentioned at the onset, the goal of these programs stay up to date on timely wealth management related topics and to collaborate where appropriate. I think we can all agree that the clients who are best prepared are the ones who are served by a team of knowledgeable advisors. 4 more quick items before I let you go. First, and most important, later today, you're going to receive an email from me with an evaluation form for the program. We'll ask you to input the code that I mentioned here today in order to receive credit. After that is submitted, in the coming days, you will receive an email from ACE Seminars with your certificate. Again, please keep in mind, please keep an eye out for an email from ACE Seminars. If you don't see that email in the next few days, be sure to check your spam folder. Again, the email with your certificate will not be from me. It will be from ACE Seminars. Second, my spring webinar series is on May 30th on the topic of qualifying for qualified small business stock, section 1202, featuring Andrew Katzenberg, partner at Aaron Fox Schiff, based in both New York and Washington, D.C. And I'll send out an invitation to this program in the coming days. In the meantime, if you have a friend, colleague, or client who'd like to be notified of my upcoming webinars, they can email me with the word webinar in the subject line, and I'll add them to my webinar distribution list. My email is jonathan@parkbridgewealth.com. Third, you can follow all my work on Twitter and Instagram at Jonathan on Money. You could also listen to my weekly podcast called Jonathan on Money, which is available on Apple, Spotify, or wherever you get your podcasts. And you can watch my new daily financial planning videos by following me on YouTube at Jonathan on Money as well. And fourth, please take 30 seconds to fill out my survey at the end of this program. It helps me improve my webinars and provide timely and interesting content to attendees. I thank you in advance for that. And with that, this concludes today's session. Please stay safe, healthy, and have a wonderful day, everybody.
Thank you. Goodbye.
Thank you.